office, Mr. Soltero. It is not related to this case. It's related to a case involving enamel management services, which isn't the case at all.
That was certainly, Your Honor, that was done inadvertently by me, and I will be happy to get the third order we had agreed to and correct that immediately.
I was going to say there's another order out there, right, that I should be getting,
yes, Your Honor.
But that isn't it. Okay, very good. Well, I've done those two. They have already been, they're on their way to being processed and filed electronically in the court file. And I'll make docket notations at some point today that we've done all of that. And then I'll look for that third order as soon as you can get that to me. Okay, very good. Then one other housekeeping matter. We've reviewed the information in the box folder, and we appreciate the effort that everybody put into putting documents in there. However, at least with regard to the plaintiff's exhibits, you understood the instructions correctly to require a separate folder for each exhibit. So you have, for example, plaintiff's exhibit number 1 in a folder called plaintiff's exhibit number 1. Good job. The difficulty there, the thing you missed, is that on the first page of the document that is in that folder, exhibit number 1, must have an exhibit sticker on it. Yours don't. So you have the documents you want in the folder, but there must be an exhibit sticker on that first page which says plaintiff's exhibit number 1. It's got to do with our ability to keep it straight, but also for appellate purposes, they require that exhibit number be there as well. So at your leisure, don't need to worry about it today, but maybe over the weekend, someone could go in and just affix exhibit stickers to all those exhibits. I think those are all the preliminaries that I have for you this morning. And unless anybody else has anything they want to talk about, then we can hear from the plaintiff's first witness. Vicki has her hand up. Yes, ma'am.
I'd like to invoke the rule, Your Honor.
All right. If you could ask those of your clients and witnesses that might currently be in our room, and I don't know if I can see everybody that's in the meeting on my one screen. I think there's just the one, but because I don't see any arrows, so it looks like I have everybody. If everyone that's planning to testify, that includes you related to attorney's fees, that includes your client representatives, that includes anybody else in this meeting that has an intent to testify, if all of you could raise your right hands, I'll swear everybody in at one time and offer some explanations. All right. Do each of you solemnly swear or affirm under the penalty of perjury that the testimony you will give in this cause will be the truth, the whole truth, and nothing but the truth?
Yes.
And just to make sure we have an idea of who's doing what, I see that Mr. Martin Floriani has raised his hand and has been sworn. Saylor has raised his hand and he's been sworn. You can put your hand down. Mr. Soltero raised his hand and he was sworn. Mr. Augustine has raised his hand and he was sworn. Mr. Brutico, did I also see you also raising your hand? He was sworn. And Ms. Dickey, I've got Ms. Dickey having raised her hand and Ms. Klingsheisen as well having raised her hand. All those folks have been sworn. Did I miss anybody who took the oath? Okay, great. So I'll keep that list handy so that I can be reminded. Ms. Burgess, I did not see anyone in your box, you or the person sitting next to you raising yours. Did you?
Oh, we did. Yes.
Okay. So, and I don't know if you could identify the gentleman next to you, please.
Is Bill Windler. And not on the screen yet is Paul Hurdlow, who we consider necessary for the litigation. Our testifying corporate representative is Ray Matuka.
I don't see either of them in the meeting at the moment, and so I've not sworn them in which case when they arrive, we can take that up. Obviously, you get to have a client representative, but you only get to have one. So
even so,
take your poison.
My understanding is under the rule that that if someone is necessary for the litigation, then they are allowed as well. And we have a general counsel who has been involved in the entire case, and so we would like that general counsel to also be able to be exempt from the.
Typically, the rule that you're referring to, if it's the same one I think you're referring to, is related to an expert who might be necessary to listen in to assist the court in understanding and also help the expert know what's going on so that the expert's testimony can be enhanced by having heard what's happening. You don't get to pick two representatives from your client because they know a lot about the case. You get one client representative, and you might, if necessary, be allowed to have someone excused from the rule who is not a party. And so you don't get two clients. I think you're mushing those two things together.
I hear what you're saying. The issue is Mr. Hardlow has only been, he would not have been a witness at all and would not be subject to the rule except for a subpoena that hasn't been served, that we, once it's served, will move to quash. So he is general counsel. He's not a witness. He shouldn't be part of the rule.
Well, if he's not going to testify, then he doesn't have to be excluded because he's not a witness. But that's not what I heard you say. What I heard you say was something I thought a little different. It sounded to me like what you were saying is you want two client representatives and one of them should be allowed in because he knows a lot about the case and has a lot of information that might be helpful. I don't understand that.
That is actually how the rule is written. But he also, although the defendants have said that they're going to subpoena him, they have not subpoenaed him. But there's no basis for subpoenaing him. He's got privilege.
Your Honor, may I respond?
As soon as I understand what Ms. Burgess is talking about, if I need further explanation or comment, I will invite others to do so. But at the moment, I'm not following what you're telling me. Here's what I'm saying. So I want to be clear. I want to be clear that we're on the same page. You get one client representative. You can pick whoever that is. That can be Mr. Augustine. That can be Mr. Hardlow. It doesn't matter to me who you choose, but you can only have one. The rule that I think we're talking about is one that might allow someone to be excused if that someone is an expert who needs to hear the testimony of others to help enhance the expert's ability to testify or assist the court in some way in understanding the testimony and so forth. I don't hear you saying that you want somebody excused under the rule for that reason. The third option, I suppose, for you to have someone else sit in and watch the proceedings is that if they're not going to be witnesses at all, in which case I don't know why we're talking about them, because if they're not witnesses, they're not, everybody else that's watching can watch just like that person can watch. So I guess
every single lawyer in this group raised their hands, even though in our flow charts, both sides said attorney's fees would be handled separately, but every single lawyer raised their hands, and Paul Hardlow too is a lawyer and should be able to advise the company and not be excluded because of the rule.
Let me correct you at least slightly, not that it's that important. Ms. Galaviz, for example, did not raise her hand. Her video's been off the whole time. She's a lawyer on the case. She's not raised her hand. She doesn't apparently intend to testify, and she's here in the room, but not sworn in, right? Because she's only going to be working as a lawyer and not offering testimony. Mr. Hardlow could be in the same category as Ms. Galaviz. She hadn't been sworn in because her video was off. She did not raise her hand so that I could see it. So I assume she's not testifying. Mr. Hardlow can be in that same category of people. If, on the other hand, Ms. Galaviz forgot to start her video, and I just didn't see her raising her hand, I'm happy to swear her in now. And if he wants to be a witness, I'll swear him in now. But you cannot have two corporate representatives. You only get one. If you have an expert that you want not to be subject to the rule, I'll entertain argument about that. But I don't see your client rep as an expert that would otherwise be excluded from the rule.
Well, on that point, Mr. Walk is not, Mr. Walk, who is our expert who wrote the book Over the Top, I would like him to be able, we're getting the dailies, I would like him to be able to review the testimony of some of the testimony in the case as an expert.
All right. I will entertain argument on that point. So she wants Mr. Wolk, who is her expert, I believe, on damages, if I'm remembering.
No, on competition. Also, Mr. Gordon is the expert on damages, and it would be helpful for him to review some of the testimony as well. we just got notice they were going to invoke the rule this morning. So because they had been really, actively saying that this needed to be in the public square and everything needed to be on YouTube, we did not expect that.
Wow, we gave back 20 whole minutes yesterday afternoon for things like pretrial. This sure would have been nice for us to have discussed yesterday so that we could have started fresh with evidence this morning. That was my goal in taking care of all of these pretrial kind of matters yesterday. Shame on you. But okay, here we are. What say you, defendants, about excusing Mr. Wolk and Mr. Jordan, who are designated as experts on various subjects, to at least be allowed to review the testimony of others, if not sit in on the proceedings?
Your Honor, we don't have a problem with the experts being in. I think that's appropriate for them to be on YouTube. Our concern about Mr. Hurdlow, I thought that, I've sent Ms. Burgess a subpoena. She's now taking the position he's not been served. We have avoided doing that in the time of COVID. If she would like us to track Mr. Hurdlow down and serve him, we are not going to ask him attorney-client privilege matters. We're going to ask him about his interaction with third parties. That's number one. Mr. Augustine is with Rokfin, and we will ask him to leave. Mr. Sullivan is an employee of FloSports, and we would ask him to not be in here unless he's the corporate representative. And I apologize, I didn't actually think invoking the rule was a very big deal. It is done in almost every case I've ever been in. And
I wouldn't have thought so either, except that we've now spent 15 minutes talking about it. And so that's my only point.
I apologize. I did send them an email this morning about it, and I did not get a response.
Okay, well, Mr. Sullivan is not on my list of people who raised their hands and were sworn. So unless Mr. Sullivan is, and I don't understand him to be your corporate representative, correct?
No, and
So
he's not a
Mr.
witness.
Sullivan,
He's just a member of the public. He's part of our team, but he's not a witness, and he's not.
well, Mr. Sullivan doesn't need access to the meeting. He can watch the proceedings on YouTube. So we'll ask Mr. Sullivan to leave the meeting and he can watch the proceedings elsewhere. Thank you, Mr. Sullivan. All right, that takes care of that one. And
Mr. Augustine also needs to go.
Mr. Augustine, I believe she indicated was, well, there he is, gone.
No, go away, Scott. Mr. Augustine, leave.
He's already gone off my screen. So, so who is your corporate representative then?
Our corporate representative is to watch the trial and assist us is Paul Hurdlow, but Ray Matuka is our testifying corporate rep.
Well, neither of them are currently in the meeting. So when they arrive, let me know. I'll swear them in and I'll give them some instructions.
Judge, I just let in somebody named Paul. I believe that's.
Well, Paul, whoever that is still connecting to audio. So when they arrive, we can straighten out who that might be and ask them to rename themselves so that we're all clear who that is. There's no objection to Mr. Wolk or Mr. Jordan being excused from the rule since they are experts. Mr. Saltero, I didn't hear you about that.
No objection, Your Honor.
Okay. All right. And still connecting here. I'm hoping that we can find out who exactly that is.
And for the record, Your Honor, there's a ruling in this case that Mr. Hurdlow is not entitled to see AEO information, and I think that's important to be put on the record as well. He is an employee of FloSports.
He's having trouble connecting, whoever it is. He should have been in by now, so let's give him just a minute to make that work. Okay, so Mr. Machuco is not in the meeting at the moment, so can't swear him in just yet. Is there anybody else in the meeting that we need to excuse for the moment? Okay, he's still having difficulty. Are we fairly confident that the Paul here trying to connect is Paul Hurdlow?
I would certainly think so, Judge.
Okay, well, do you want to wait for him since he's your corporate rep?
It's okay. I'm sure that he'll catch up.
All right, Ms. Dickey, you have another question?
Yes, Your Honor. I wanted to let the court know that Mr. Brutico is going to be the lawyer in charge of the next couple of witnesses. So you'll be pleased to know that I'm going to seal my lips. And we didn't quite understand how you wanted us to proceed in terms of order of questioning. If some of us had prepared to carry the weight more on one witness than the other. And it, like, for instance, Mr. Soltero will clearly question Mr. Saylor first. And we just wanted to understand the court's instruction.
So it's really fairly simple, but I appreciate your confusion a little bit. The way that I intend for this to work is that we will always go in this order. Ms. Burgess will speak first, then Ms. Dickey, then Mr. Soltero. When Ms. Burgess calls a witness, it's pretty easy. That's the order we'll go in. When you are in Rokfin's case in chief, Rokfin's lawyer, theoretically, will be calling Rokfin's witness, and Rokfin's lawyer will go first, and then Mr. Soltero, and then Ms. Burgess. When Mr. Saylor's case in chief arises, and he is responsible for calling witnesses in his case in chief, Mr. Soltero, theoretically, will call a witness, and then Ms. Burgess, and then you. So we will always go in that order: Burgess, Dickey, Soltero, regardless of who's calling whom or who's not calling whomever. Now, if you and Mr. Soltero are working together and you have sort of designed by way of whatever agreements or schedules that you have, that's still not a problem, even if you're not in your case of chief and he's taking the witness, because you'll simply just say, I don't have any questions at this time. We'll go to the next person. And before we're done, we'll come back to you. But we will always go in the same order: Burgess, Dickey, Soltero, Burgess, Dickey, Soltero, regardless of who calls the witness. Make sense?
Yes. And this morning it'll be Mr. Brutico instead of Ms. Dickey.
Right. Got it. Anything else? I still don't see Mr. Hurdlow connecting, so he's clearly having some difficulty. Somebody on your team, Ms. Burgess, might want to just tell him to try again or something. All right, let's proceed. Mr. Wendler, you've been sworn, sir. If you would please state your name for the record.
Philip Asher Wendler.
And would you spell your last name for the record, please?
Yes, W-E-N as in Nancy, D as in David, L-E-R.
Thank you. And does Philip have one L or two?
One L. Thank you for asking.
All right, let's proceed.
So you've already stated your name. Could you introduce yourself to the court, Mr. Wendler?
Yeah, I'm the Senior Vice President of Global Rights Acquisition for FloSports.
And just so the court knows, we're in a split screen, but we're across plexiglass from each other. Is that correct?
That's correct.
So it may look strange, but we are in the same room. We're just across plexiglass from each other so that we could actually interact. And that's why you saw us with masks as we came in and got situated. So again, tell us what you do for a living.
So I run our rights acquisition department. And so my and my team's job is to go out and acquire sports media content rights. That can be live events. It can be more written form content like recruiting and rankings. It can be data oriented stats and schedules and such. But our job is to identify content that we think is valuable and acquire it for our company so that we can monetize it on our platform, both through subscription revenue and advertising.
And how long have you been doing that, Mr. Wendler?
This role I've been in 5.5 years. I've been with the company 7.5 years.
Now, as part of your job, do you keep up with the competitive landscape?
Absolutely, it's critical. There's a lot of competition. We have 25 different sports and worlds that we live in. You know, there's a lot of people that are directly competing for those eyeballs in specific sports or sometimes across the board. So myself and my team are constantly reading the trades, going to conferences, meeting in person with both rights holders or content holders, and with competitors directly.
Now, do you consider a FloSports Rokfin to be a competitor?
Yes.
What prompted you to start following Rokfin?
At first, they had started to bring on some athletes that we were currently working with that were prominent wrestlers, which kind of caught my eye. And then obviously as Willie left abruptly and joined Rokfin with very similar content that he was producing on Flow. And then most recently with some of the live events that they've started to distribute.
Okay. Now let's go back to you. Start with college and tell us about your career highlights.
Yeah, so I graduated college, degree in economics, decided to go into sports marketing, worked for a boutique firm called the Gazelle Group. We produced events. I had a lot of different roles, from running the events themselves to scheduling, selling our media rights, marketing, promotion, PR, selling tickets, etc. We were also agents for college coaches.
And where'd you go to college before you move on?
Oh, Princeton University.
And did you play any sports there?
Played football.
Okay, after
you want to hear about those highlights, or
yeah, not a highlight
Okay.
reel, but you're right. So tell us about the rest of your career highlights.
Yeah, so from there I left to a high school sports media company called School Sports Inc. To start an events division. 6 months or so after I got there, they were acquired by ESPN. At ESPN, I was able to move into a group called Sports Management, which is in the kind of the sales and advertising division of ESPN. One of the unique things that my group got to do is we were the first integrative media experts, where typically we would work with a digital team, a linear team, print team, an event team. Our group got to kind of own all those assets, and we would bundle them together to create powerful marketing programs for advertisers like Gatorade, Nike, etc.
And did that cross-pollination work?
It did. It did.
Did it build value for ESPN?
It built, yes. So it drove more revenue. We were able to kind of bring more pieces together for the company, and also build more effective advertising campaigns for the advertisers.
Mr. Windler, do you have in front of you a notebook that has a 160 marked in it? And that's a cue for you, Mr. Weisrott.
I don't think I have that one actually.
Okay, that is the PIIA.
Yeah.
I can get that one.
Or if we have it on the screen.
Yes, Mr. Weisrott, I'll get it as well. When did FloSports start making sure everyone had signed these?
I think it was in 2014.
Your Honor, I object. There's no foundation that Mr. Windler was at FloSports or has any personal knowledge of this, and he's not a corporate representative.
I'm sorry, I started at FloSports in 2013.
Yeah, I just PIIA.
Your Honor, I withdraw my objection.
Did you wish to offer 3 into evidence?
It's FloSports 160, plaintiffs 160. It's marked 3. As you noted, our exhibits need to be marked on the first page. But
All right.
this one
So
is from a previous.
just so our record is clear, what you're asking this witness about is plaintiff's exhibit number 160.
Yes, Your Honor.
Which is what exact? Just describe it very briefly.
It's the contracted issue. It's the contract of the proprietary information and invention agreement with Willie Saylor.
Often referred to as the PIIA.
Yes.
Is there any objection to
No objection, Your Honor.
exhibit
Objection.
number 1? If you all would let me finish my sentence, our record would be clear. Our court reporter would be happy, please. Is there any objection to plaintiff's exhibit number 160?
No objection.
No objection, Your Honor.
Plaintiff's exhibit number 160 is admitted. Thank you. Go ahead.
Okay, now do you have in front of you the PIIA, Mr. Windler?
I do.
And you see that Mr. Weisrott had it on the screen as well, correct? Can you see it on the screen as
Oh,
well?
yes, sorry.
Okay, and what happened in 2014 that prompted the company to get these all signed?
I believe it was because of fundraising going through our Series A.
Okay, what is a Series A?
We were raising money through venture capital, private equity, to help to invest in our company, give us more capital to invest in the business.
And did that private equity company require that you have non-competes and confidentiality agreement?
That's my understanding.
And did you sign one?
I did.
Did you note that FloSports took this obligation to secure these very seriously?
Yes.
Let's look at page 1, the first section on confidentiality.
Mhm.
And is it true, actually, Mr. Weisrott, it's the section that starts at 1. And Judge, you may already know this, but Mr. Weisrott has been hired by both sides to handle the exhibits. He doesn't work for either of us. We've agreed to pay him collectively, so he is not my paralegal or their paralegal. He is a independent agent.
Good to know.
Okay. And Mr. Windler, when you look at the first 2 sentences, the company promised to provide proprietary information to Mr. Saylor. Did that happen?
Yes.
What kinds of proprietary information?
I mean, most of our businesses run on data and understanding of the value of certain things, both from subscription, again, traffic that we monetize through advertising. And so, being on the content team, he would constantly be looking at the results of his work to understand the value, how to improve it, how to continue to evolve it so it became more and more valuable throughout his tenure.
And Mr. Weisrott, if we go to the next 2 paragraphs. So you define proprietary information here, and then you talk about third-party information. What kind of third-party information was Mr. Saylor privy to?
As far as
did he receive information from coaches and other?
Oh, God, yeah. So I mean, he was obviously an editor on the wrestling side. He was, constantly in the community talking to coaches, athletes, parents, receiving data from other people that could support our business. I can't speak to his department, but I know they work with a lot of freelancers and other people outside of the company as well. But yeah, there's a lot of folks. Content is one of our biggest departments. So we've got a lot of pieces. Again, that's not my department, so I don't have the expertise there. But I know Willie was very active in the community.
And if you turn, Mr. Weisrott, to page 4 and look at paragraphs, or numbered paragraphs 4 and 6. In the PIIA, did you agree that when you left the company, you would return proprietary information, that you would not use proprietary information, that you would actually return it?
Yes, that was made very clear.
Let's go now, Mr. Weisrott, to page 2, section 3. And let's start with 3B. What are the commitments that you made to FloSports and Mr. Saylor made to FloSports about competing after you left?
Your Honor, I'd like to object on foundation about his knowledge about what Mr. Saylor agreed to.
Well, so the agreement speaks for itself. Certainly you can ask him a question about something that is contained in the document that now has been admitted into evidence, but But the language is here for us all to see. And so I guess I'm just a little puzzled about what exactly you're asking him that we can't discern from reading the document's own words.
I'll move to the next question, Judge. There are three different obligations here. The first one is not to compete, but the second one, it talks about in the geographic territory to participate in the ownership, management, operation, financing, or control of a person, corporation, or entity that's engaged in the business of the company. Is Mad Scouts engaged in the business of the company?
Yes.
Objection, same objection, Your Honor, Foundation.
I'm going to overrule the objection because it's not timely. He's already answered the question. So let's move on.
Can you instruct the witness to give me an opportunity to object? You
Well,
answered pretty quickly.
You have that opportunity. I believe the witness is aware of it. You'll still need to make them timely. When you hear the question, if it sounds objectionable, make it as soon as you can, and we'll go from there.
And I believe you previously said that FloSports considers Rokfin a competitor.
Yes.
All right. Let's go to, if we go to section 3, at the beginning of section 3, mine is front and back now, 3.1 on page 2. It talks about what the business of the company is. What was the business of the company in 2014, and what was the business of the company in 2014?
Yeah, it's not too different than it was now. We're a sports media company. We monetize sports media content on a direct-to-consumer model through subscription, and we also have advertising on top of it. In 2014, I don't know if we had, I think we started to have live events as well. We definitely had them during Willie's tenure that owned and operated live events that we actually produced. So with that, we also have ticket sales, merchandise, and other forms of revenue.
Okay, and all of those things, live events, content, owned and operated events, are all of those products and services in the sports video industry that were the business of the company?
Objection leading.
Sustained.
Yes.
Hang on, sir. She's going to ask you another question. Please don't lead the witness, Ms. Burgess.
Yes, Your Honor. So what do you consider the products and services of the sports business, the sports video industry, or the business of the company?
Yeah, so FloSports is more than just a distributor of video or live video. We've always had this more comprehensive model. That's why our content team is one of the biggest departments, because it has value in itself, and that we're able to monetize our written content, our video content, non-live event content, as well as the live events. And the live events also bring in subscribers. And from my job in trying to procure those live events, one of the big advantages that I'm able to offer folks is the ability to bring content along with the distribution of the live events. Because a lot of times we're not even producing the events. We're just taking a feed and we're just a distributor. They're using our platform.
And are those products and services of FloSports that FloSports offered in 2014?
They were. That's why Willie had a job.
Right. What department did he work in?
In content.
Okay. So what were the products and services that Willie Saylor was offering?
He was on the editorial side, content team, providing content for Flow Wrestling. He did work on a couple other things. I know I went to a rodeo with Willie, and he was interviewing them as well. So it was more than just wrestling, but his primary focus was wrestling. He had been with the company a long time, and he had really been built up through his own work and the company's promotion to become one of the leading voices in the wrestling community.
Now, let's go to Mr. Weisrott. Let's go to PDF page 3, section 3.2. It's at the bottom of page 3.
Okay.
And the non-compete says that it is told while there is, while competition is going on. Did the temporary injunction stop Willie Saylor from competing with FloSports?
Objection, Foundation.
Same objection.
The temporary injunction, which by the way, I ordered I'm going to take judicial notice of it. It also speaks for itself. I don't need him to tell me what he thinks it means.
Right. I'm just asking about whether he was stopped from competing. And let me just change the question.
Well, I think that's going to be difficult for him to answer with a kind of yes or no answer, right? Because some things are carved out, some things are strictly prohibited. I mean, the document speaks for itself. The order is what the order is. What's your question
Right.
about?
My question isn't really about the injunction. I'm saying,
I thought as much because it, as I said, it speaks for itself. So let's get to the sort of the heart of what you want this witness to tell us.
certainly. Has Mr. Saylor continued to compete this year?
Yes.
Okay. And in terms of live rights, what has Mr. Saylor done?
Object to the form, calls for speculation.
Overruled if he has knowledge of what he's done. If he doesn't, you can cross-examine him on that. And I'm asking, of course, all witnesses to be limited to things that they have personal knowledge of. Go ahead.
Yes. So we've been in talks with the Nittany Lion Wrestling Club, my team.
Sorry, this is the
I'm sorry.
I didn't hear what you said, the witness said.
And it's okay because the witness is not answering the question that he was asked. So let's be clear about the question. As I understood it, it was in what way does he believe that Mr. Saylor competed? I could be wrong about that. So I'll ask Ms. Burgess to clarify her question.
No, that is, and that's the question that he's answering.
No, his answer had to do with him having a conversation with someone else, not the answer that I was listening for. The question's simple. What, in his opinion, does he think Mr. Saylor did to compete with FloSports after the temporary injunction?
Certainly.
Yes. And so there's still content being created that we see as competitive. There's also communication with rights holders for live events that we see as competitive. We were pursuing the same rights.
Thank you.
Excuse me.
Other sheet. I lost my place here. Okay, so let's talk about FloSports. Let's look at Mr. Weisbrot 242. This is one slide from. Can you identify this?
This is a slide that we use in a number of decks. My department had used. I think we had used in fundraising. You know, it was created, probably around the Series A. And what it says.
Don't tell me. Hang on. Let's get some clarity around how we're going to do this, particularly since we're putting things up on the screen for people to identify. This is one of the reasons why pre-admitting the exhibits would have been so valuable, something for us to accomplish that we failed to do. But in any event, I need to know what exhibit you're asking him about, what trial exhibit, not what was used in someplace else. He can tell me about that later, but for clarity, for all our benefits, we need to know what you're showing on the screen. So what plaintiff's exhibit number is it? Let's get that clear. Is there any objection to it? Then we can have people testify about the content of the exhibits. So
thank you, Judge. When I asked Mr. Weisbrot to bring it up as F242, that's plaintiff 242. But I'll say it. I think the parties agreed to call it that in Ms. Galavise's conversations. But I'm happy to say plaintiff's 242.
If you want the court reporter to understand what exhibit you have, if you're using F as FloSports, that's fine. We can follow your code. You just have to tell us what it is. So if this is FloSports exhibit number 242, fine. If that's what this is that what this is?
It is, Judge.
All right. Does anybody have any objection to FloSports exhibit number 242?
I just want to confirm, Your Honor, this is a one-page exhibit.
It is. Mr. Weisbrot is nodding his head as well. That's the most important person because.
All right. 240 plaintiff's 242 is a one-page document, and is there any objection to it?
None, Your Honor.
No objection, Your Honor.
Plaintiff's 242 is admitted. Okay, go ahead. Now you can talk about the content if you like.
Thank you, Judge. So there are some acronyms here. Can you walk us through them?
Yeah, it says we are an OTT, OTT standing for over the top, which is, basically it's a distribution of media around the cable box. So it's probably an outdated acronym now, but it's still used pretty commonly in the industry. And we say direct to consumer, which is kind of a similar reference, but DTC is direct to consumer, meaning that we're going direct to customers to market our platform where they can sign up for the subscription. And again, we want to build traffic to also increase our advertising revenue opportunities. And that's the kind of basic definition of our company. I think I had also said that earlier.
Okay, and has that changed since FloSports started?
It has, and this was before I got there, but originally they were an advertising-based model. They did not have subscribers, and they were reliant on advertising revenue. They moved to the subscriber model, I think it was around 2011. So a year or two before I got there, and they found that would seem to be a much more sustainable model. And since that time, it's been pretty consistent.
And was that the case when Mr. Saylor and Martin Floriani signed the PIIA?
Yes, it was.
Okay, and is that also what Rokfin does?
It is.
Okay, and let's go to F873. Can you identify this document?
Yeah, it's a press release talking about a new wrestling specific partnership that Rokfin has confirmed.
Okay, and then can you read the first line of that?
No, he cannot read from the document until it has been admitted into evidence. I
sorry.
thought we went over that.
I'm sorry, Deb.
Let's just remember that at lunch, you all are going to have another conversation about pre-admitted exhibits so that we don't waste time with this and with who's got an objection and who doesn't. Again, I thought that was all sort of the stuff of yesterday's time together, but
this actually was used in the opening, so I can't imagine there's an objection, and
yet our record begs for clarity. So, to provide such clarity, is there any objection to Plaintiff's Exhibit 873?
No, Your Honor.
No, Your Honor.
All right. Plaintiff's Exhibit number 873 is admitted, and now you may ask him about the content of the document.
Yes, Mr. Windler, do you have that in front of you? And it's also on the screen. Could you read the first sentence?
Rokfin, a subscription media platform, is a new model for subscription media companies and creators to monetize their content.
And is that also what FloSports does?
Objection leading.
Sustained.
Does it matter that they call themselves a platform? Does that distinguish them?
I mean, it doesn't matter. We would call ourselves a platform. The Rokfin offers a kind of a revenue share model. Their currency is different than what we would offer people, but we actually offer the same thing to several partners. We don't have a fixed way that we secure partnerships. Sometimes it's a flat rate, sometimes it's a revenue share, sometimes it's a hybrid of the two. Just depends on the opportunity. The only difference is that we pay with American dollars and they pay with cryptocurrency.
When Martin Floriani was at FloSports, did he ever talk to you about using cryptocurrency to pay content providers for FloSports?
He did.
Hey, tell us about that.
I remember Martin was trying to think of ways to help keep our partners more engaged, and cryptocurrency was coming out. He was really excited. I remember him specifically being excited about the Ethereum model, and that he was brainstorming ways where we could use it as a currency to compensate rights holders and kind of keep them locked into our platform.
And has FloSports gone in that direction?
We have not.
Would it change anything about the business of the company itself?
No, as I said, it's just a form of compensation and consideration. Our contracts aren't just, it's not just pay for content. We provide a lot more services. Again, content's typically part of that marketing, promotion, sometimes production, sometimes not. We've got back-end services like customer support, network operations technicians. We got a lot of people involved, and there's a lot of overall value that we invest into every partnership deal that we bring on to FloSports.
Does it make Rokfin, does it change Rokfin's, your consideration that Rokfin is a competitor, that they're registered with the DMCA?
No, it does not. FloSports is registered with the DMCA. I believe anyone can register with the DMCA. It doesn't change things. I mean, even, you know, when we look at other platforms like social media, you know, there's a lot of competition there as well. When I go to major conferences where it's the biggest, you know, there's one called Sportel, it's the biggest buyer and sellers of sports media content in the world. Facebook and Twitter have huge booths there.
Let's go to exhibit, I just heard that, 6, okay, F632. Can you identify this document?
Yes, you know, this is a screenshot of a website that's part of PA Power Wrestling, and seems to be alluding to the fact
Wait,
that—
wait. We have to, now I need to move for admission of 632.
The objection?
I would object on hearsay.
It's Rokfin's own website. It's an admission of a party opponent.
Are you testifying that it's on
Oh,
Rokfin's
let's
website?
remember a couple of other basic rules, Mr. Burdico. You don't get to have a conversation with Ms. Burgess. You get to have a conversation with the court. Ms. Burgess gets to have a conversation with the court. If you two need to confer, I'll put you in a conference room and you can chat all you want. But when we're in the court session, which we're currently in, you talk to me. So, do you have an objection?
Yes, Your Honor. I was objecting on hearsay. I did not understand the witness to be testifying that this was Rokfin's.
Ms. Burgess suggests to you and to me that this is a Rokfin document. Are you saying that Rokfin produced it?
No, it's on Rokfin's website.
All right. So is there someone that can sponsor, a witness that can sponsor that that's a fact, that it's on the Rokfin website, since Ms. Burgess can't so testify?
I can.
All right. Well, let's do that foundational work first. Ms. Burgess, you may ask further questions on that matter.
Yes, Mr. Windler, did you look at this on the Rokfin website?
Yes.
Any other objection to plaintiff's exhibit 632?
No, Your Honor. Thank you.
Mr. Sotero?
No objection, Your Honor.
Plaintiff's exhibit number 632 is admitted.
The last exhibit we were looking at also referenced PA Power Wrestling. Does FloSports stream any PA Power Wrestling events?
We do. We stream the event listed in the top left corner of the Powerade Wrestling Tournament.
And is that an exclusive stream?
It is.
Yet this lists Rokfin PA Power Wrestling.
Yeah, it's confusing. They do not stream that event. It appears they're trying to represent that they are.
Your Honor, I would move to strike. There's no trademark or Lanham Act claims in this case, or trade dress, so it's irrelevant. And
Well, more simply put, he can't testify about the motivation of others. So it appears that they're trying to do something is going to require him to speculate about what's in the mind or motivation of others, which he simply cannot do. So let's move on.
Sure. Do you consider this competitive?
I do. It says specifically that it lists these events and then says Rokfin PA Power Wrestling live streams, articles, recruiting.
Now, how do you and have you seen, is Rokfin streaming live events?
Yes, they are.
How do you prioritize, and we can take down this particular one, Mr. Rice, for it, because it may be taking up people's screen space. How do you prioritize at FloSports the live events versus content. We've heard a lot of separation of that from the defense.
We don't. We look at it all as kind of content and try to understand the value of it. We're not just focused on one side or the other. And so we know that content is a huge advantage to our business. It's helped to drive and retain subscribers as well as the leading driver of traffic on a daily basis. And with our model, especially in the subscription service, you've got to understand kind of how to retain those subscribers, not just get them in, but keep them. And so having content that would be evergreen, right, not seasonal, because the sports season may only last a few months. We've got to be able to create powerful and compelling and engaging content that's going to bring users to our site on a daily basis.
And is that what what Willie Saylor did?
Yes.
How does FloSports allocate resources between content versus live events?
Content is one of our biggest departments, right? And so they've got a huge amount of people, a very large budget, because they've got the challenge of kind of covering the events that we're doing, cover the sports that they're in, as well as creating, these kind of tentpole content features like rankings, recruiting, other kind of data-driven assets. And then we've got other sides of our business that are, doing live event production, live event management as well. But it's now a big company. We're, closing in on 300 employees. So we've got a lot of resources on all sides, because we see all sides as not only important, but valuable, and not as an opinion, but as we measure the data that we look at on a daily basis to understand how we make decisions, how many people we hire in different departments.
How does COVID impact the importance of content?
It makes content more important. There was a stretch where there was absolutely no events, and still today we have a huge volume of events that's been canceled due to the impact of COVID. And so again, we're a subscription business. We've got to not only attract subscribers, we've got to retain them. We have an advertising model. We've got to continue to get traffic. With no live events, we are solely reliant on content. And we found that, by getting creative and continue to improve the content areas that we know are successful, we've been able to be successful there and drive subscribers, continue to grow our platform, hold off churn at a better than expected due to the loss of live events and the ability to cover live events. So it's become a really powerful part of our business that was highlighted during COVID.
Has Willie Saylor continued to provide content on Rokfin during this time?
Yes.
Let's go to F72. And can you identify this document?
Yes. Do I need to wait for anything?
Just identify it. Don't read from it, just identify it.
Got it. It's basically, I think it's from Rokfin's website as well. It's a statement just talking about how they bundle their content, similar to FloSports.
And I move for admission of F72.
No objection, Your Honor.
No objection, Your Honor.
Plaintiff's Exhibit 72 is admitted.
Okay, so is this sometimes called the network effect?
Yeah, I mean, that's a term that we've used at FloSports for years as well. A subscription on FloSports, if you sign up for Flow Wrestling, you get everything on FloSports. You get every channel, every sport. And so it's a very similar offering, and that one subscription gets you the whole platform.
And do you pay, to get Flow Wrestling, do you pay FloSports?
Yes.
And to get Rokfin, do you pay Rokfin?
Yes.
Even if you're getting live events from Nittany Lions or content from Willie Saylor, is that true?
It is.
Objection. I didn't understand the question. Leading.
I didn't understand your objection. I'm sorry, what's your objection?
I'll object on leading.
Leading objection sustained.
Who does a consumer pay in order to buy wrestling content on FloSports?
FloSports.
And who does a consumer pay to buy wrestling content on Rokfin?
Objection, Your Honor. This calls for speculation. I don't think it's been established he knows anything about how Rokfin actually works.
Is this in dispute, gentlemen? Really? Is it in dispute that the people who do business with Rokfin pay them and the people who do business with FloSports pays them? Is that really an issue in dispute? I don't think so. Let's move on. Ms. Burgess?
Now, yes, Your Honor. How has this played out for Rokfin? And we're going to go to F14, which I think is just a demonstrative.
Okay, I have that one.
Yes, that's not. I think that's a pleading. Never mind. Don't pull that up, Mr. Weisrod. Did you see the demonstratives yesterday that showed Rokfin's outward-facing dashboard?
Yes.
And are those things you've seen before in your role at FloSports?
Yeah, so as I mentioned before, part of our job is to monitor all of our competitors, how they're doing, how they're positioning themselves. And so that dashboard is public. We've watched it. I've looked at it first, I think, when they brought on the more prominent wrestlers to create content, wrestlers that we were actively working with at the time. And then as Willie Saylor came on, and then, as they started to do more prominent live events.
And how did Rokfin subscribers change when Willie Saylor came on board?
Objection,
Not
foundation.
surprisingly, they
Excuse me, there's been an objection. Excuse me, Mr. Burdico made an objection, but I think it may have been difficult to hear him. So first, if you could repeat what you said, and secondly, in the future, if you could speak up just a little bit, that would be helpful. What's the objection?
Objection, foundation, Your Honor. Lack of personal knowledge, lack of knowledge of how this witness knows these facts.
Not entirely clear, Ms. Burgess, but you certainly can have an opportunity to clear that up. So I'll sustain his objection.
Certainly. And how do you know that in your job? How do you know about Rokfin subscribers in your role at FloSports?
It's publicly available on the internet.
And do you monitor that as part of your job?
Yes.
May I proceed, Judge?
Please.
Oh, you're frozen. Are we off? Are we frozen?
Ooh.
Or they...
Can you guys hear us?
Yes.
We can hear you, and you may ask your next question. Can you hear us?
I'm sorry, you all are frozen for us. We can hear you now, but we lost you for a minute there, and now you're unfrozen.
So you have not been frozen, at least
Thank
for
you.
me. So I wonder if maybe that is some internet connection issue on your end, because you've not been frozen at all on my end, at least. I don't know what others' experiences have been. But for now, let's just keep moving.
Got it. Thank you. And so how did, I think you testified, or let me have you testify again because there was an objection. How did Willie Saylor's first month at Rokfin change Rokfin's subscriber base?
First month he came on, Rokfin's subscriber base doubled. I don't have the exact numbers, but I know it was in the low thousands, and I think it went over 3,000.
And how was it affected when Nittany Lions came on board?
It doubled again. And the unique thing from my perspective was that these were the only times that they had this level of significant growth, combined with this kind of flywheel effect of, it's very similar to what Flow Wrestling does and FloSports does, is, hey, let's bring in the content, let's bring in events, and then you build this, create this ability and model, not only to be able to bring in subscribers, but to retain them and continue to grow that subscriber base.
And do you call the value of that the lifetime value of the subscriber?
Yeah, so the life.
Excuse me,
Or,
Mr. Burdico, I think some of the difficulty again is when you're sitting back, we don't hear you as loudly. Perhaps you could turn up the speaker volume on your device. that might help, I hope. If you increase the volume of your speaker, we might be able to hear you better. But Ms. Burgess and Mr. Wendler, if you would, when you hear Mr. Brutico or Mr. Soltero say anything, assume it's an objection, and please stop your testimony, sir, until I have a chance to deal with their objection. What's your objection, sir?
Objection leading.
Sustained.
Can you tell us what lifetime value is?
Yeah, lifetime value is referring to the value of each individual subscriber on average. I think the way you technically calculate it is times the acquisition price divided by the churn. But basically what it nets out to is what's the average subscriber being worth over a 3-year period.
And with regard to the Nittany Lions event that doubled the Rokfin subscribers, had FloSports been competing for that event?
Yes.
Now, let's go to what is, Mr. Weisrod, it's 255. Can you identify this document? Just identify it.
Yes, it is Rokfin's mobile website with a mobile ad for a live event.
Move for admission of F255.
No objection, Your Honor.
No objection, Your Honor.
Plaintiff's exhibit number 2255 is admitted.
Thank you, Your Honor. So can you describe this ad?
Yeah, it's an ad for I believe the first Nittany Lion Wrestling Club, the NLWC event on Rokfin in September 19th, event that we competed for.
And do you know who all competed for that event?
I do. It was Fight TV, Track Wrestling, Flow Wrestling, and Rokfin.
Okay, and tell us generally about competition for media rights, particularly in the time of COVID.
So there's less events during COVID, right? And in recent times, there's a lot more sports media companies that have popped up that are looking for live content to compete for and to distribute. And so, you know, there's just a lot more pressure and more people involved, and it's very competitive.
Now, speaking of rights holders, are terms of agreements with rights holders confidential at FloSports?
Yes, very.
Is the calculation of lifetime value confidential?
The calculation of lifetime value is confidential. Also, the value of events, the value of specific types of content. Again, we try to measure the value of everything that we do. Our company's incredibly data-driven. Willie had access to that data, and you know, it's something that we protect. This is part of the big reason that we have the non-disclosure agreements, the non-compete agreements, password protected logins for areas where there's sensitive data.
Are the terms of your rights holders agreements, do you have NDAs in those as well?
Yes, we have a confidentiality clause in all of our rights agreements.
Now, looking back at this document F255, what did one have to do in order to purchase viewing this event?
They would have to pay for a Rokfin subscription.
Now, you can take that down, Mr. Weisrod. If terms of rights holders agreements got out to competitors, how would that impact FloSports?
So anytime that there's, you know, specific data on events, and so it could be the terms, but also the value of events. You know, it just, if the competitors have that information, it's very valuable. When you know what something's worth, especially in a very similar model, you know how well you can do, and then that helps you understand how much you can invest.
In this case, have you seen that Mr. Saylor gave Rokfin a list of easy targets for live events?
I have.
Objection calls for hearsay, Your Honor.
Sustained.
If if Rokfin got a list of the events that Saylor believed were easy targets, how would that impact FloSports?
Objection calls for speculation.
I'm not sure I followed the question. If he did this, how would he imagine that? It's very confusing, Ms. Burgess. Perhaps you could clarify your question a bit.
Sure. Let me ask it this way. If would Rokfin in your competitive landscape, is Rokfin targeting the same live events you are?
Objection, Foundation.
Overruled. You can answer that question if you know, but you have to tell us how you would know what their strategy is or how you would know that they were doing it. So if you can answer it, you can answer it, but before you answer it, you must tell us how you know.
Yeah, I don't think it's that complicated, Your Honor. You know, the wrestling community is not a massive community, right? It's a very specific audience. With Flow Wrestling, we have a very specific product. It's wrestling content, wrestling events, right? What Rokfin is pursuing with Willie Saylor's content, with events like the NLCW Freestyle Live event, and the other events that we hear them pursuing, is trying to create a very similar product, offering very similar sports media content and marketing to the exact same audience.
Well, I can appreciate that explanation, but for the benefit of the lawyers, let's get some things clarified here. First and foremost, if you're alleging that Rokfin went after a particular event and therefore was in competition with FloSports related to that event, leaving aside for a minute whether that's relevant or not relevant for any other reason, the point here is whether or not you know that Rokfin went after that event or some other event and so forth. And so the reason for the reason for the objection is that they want to be clear, and I do too, about what you have knowledge of about what Rokfin and FloSports were competing about. I appreciate that in your opinion, Mr. Windler, you believe that the two companies are in competition. I get that. What I'm not clear about here, because Ms. Burgess is asking you questions about specific events, is A, whether you know for sure that the two companies were competing over A event or B event or C event, not that generally they were in competition with each other in this industry. So to the extent that your opinion is that generally they were in competition, I understand what you're saying. But if you're going to tell me that they were in competition over media rights for a specific event, then I need to know how you know that they were in competition over that specific event. You understand the distinction there?
Yes.
All right. So I'll ask Ms. Burgess to ask you another
question. Do you want me
question.
to ask him a question, or can he?
You can ask him. You can ask the next question.
Can I speak to another exhibit?
You sure?
Excuse me. If you two need to confer, you should mute your microphones while you do so. Right now, we're just listening for a question from Ms. Burgess and an answer from Mr. Windler.
Certainly. So I'm just going to repeat what the judge is asking you so that it's in a question answer form. So I'm going to break it down first. Does FloSports consider Rokfin a competitor generally?
Yes.
Okay. And what are you competing for with Rokfin?
We're competing for the wrestling community, like time on our website, subscribers, with the same content.
Okay. Are you also competing with regard to rights holders?
Yes.
Generally.
We're competing with, right now, it seems to be focused on the wrestling rights holders.
Okay. And as a subset of the competition for wrestling rights holders, do you know of any yourself, particularly that Rokfin streamed?
Yes. So there's the Nittany Lion Wrestling Club, and then there's the PA Power Wrestling Association, whatever it was. I've also, I believe it's been documented that Willie had a list of events that he was targeting that were currently under contract with FloSports. I think there was 5 or 6 events.
And do you consider that competition?
I consider that confidential information, and I consider that a plan for direct competition for our active partners.
Do you know that Rokfin uses Flow Wrestling audiences for its paid advertising on Facebook?
Yes.
Okay, and is that a way to target your competition?
Objection leading.
Yes.
And Your Honor, I'm going to also object on the grounds that he's a fact witness, not an expert witness. That was very clear from yesterday, and I believe this is crossing the line into potential expert testimony.
I'm not sure that's the case,
I'm
but
gonna ask a different.
but it is definitely a leading question, and I'll sustain that objection.
What at FloSports, what do you use target audiences for?
We try to target specific audiences that we know will convert more, and we test that and measure that, looking at the ROI, return on investment, when we're spending on social media platforms like Facebook, Instagram, YouTube, etc. And so, you know, if we know there's a competitor out there that has the audience that we want, you can actually buy that audience through social media and specifically target them on social media, even through Google in just their AdWords, right? So you can get very specific and hyper-focused. And again, from what I've seen, they're targeting our exact audience, which again, the only reason you do that if you're trying to compete with us for similar content.
Now, do you ever partner with some of your competitors for a win-win?
We do partner with some of our competitors. Usually we do it in ways that we think that we can win. Hopefully they win as well, but I can't speak for them.
Now, let's look at 665. And can you just identify this?
Yeah, so this is a dashboard from Periscope. Periscopes are kind of a data warehouse. All of our analytics kind of are pumped into it. It allows us to pull really specific information about you know, almost anything that we do as a company. This dashboard specifically shows Willie Saylor's usage by month, starting from, looks like 2017 through his departure in 2019.
Okay, and I move for admission of 665.
The objection?
No objection.
No objection, Your Honor.
It's admitted.
Okay, and let's look at 666 as well.
Am I allowed to call out something specific on?
Sure, well, I was going to get both of these in
Okay,
and then
okay.
come back to what you talked about the exhibits. Let's look at 666 as well because it's on the same point.
It's been offered, gentlemen. Is there any objection to 666?
No, Your Honor, no objection.
No objection, Your Honor.
Plaintiff's exhibit number 666 is admitted.
Okay, and what can you tell from exhibit 665 and 666 about Mr. Saylor's conduct?
If you look at the recent history in 2019, you see kind of a spike in around February, looks like January through March. Seems to be overlapping with when Martin and Willie were having discussions about Willie coming over to Rokfin. And then the big spike you see at the end is the month before he left. And then if you drill down to the specific days on the next exhibit, you see as he was preparing to leave, he had an even bigger spike. And then I believe he left on the 2nd. He had quit, so it wasn't like the company was prepared to shut down all of its access to everything. And so it looks like he continued to access Periscope the day after he quit to gather whatever information he was looking for.
Well, couldn't he have just gotten on there to figure out what his commission would be?
He wouldn't need to do that. The company can do that. So.
And what could you tell by looking at these comprehensive attribution dashboards?
The comprehensive attribution dashboard is a different dashboard. It's not the one that we're looking at. It's a really powerful dashboard in that it gives you a ton of information for the whole company. You can kind of curate down to specific sport channels like Flow Wrestling and specific time periods. But when you run it, you get all of the subscriber information from all the subscribers that came in during that period on whatever channels you select. And so with that, you would have specific information on subscription upfront, cash from subscription and viewership data for every event that falls within that query. You'd also have understanding of the different pieces of content that we put out, how many subscribers and how many clicks that each of them got. So you really have a huge snapshot of the value of our entire business in different segments, both live events, content, and other things.
Now let's go back, Mr. Weisrott, to 665, the second page. So it's the tab before and it's on the back side. Okay, and can you tell the court what the first long arrow or long bar shows?
Yeah, it shows that Willie spent, looks like, over 90% of his time on the comprehensive attribution dashboard and did not look at many others.
Okay. Now, you were talking earlier about competitors that you sometimes partner with. Have you ever partnered with Rokfin?
We have not.
Do you consider a platform like Facebook to be a competitor?
We've competed with Facebook, so yes.
Okay. Does it surprise you that some folks, some subscribers on Rokfin who were already FloSports subscribers did not cancel when their subscription came up?
No, I mean, that sort of attribution or just the churn, that happens over time. Rokfin is still young, right? They're starting to build their content offering, and again, I spoke to them. Their plans, from what I understand from Willie's communications, to grow that. And again, it's the flywheel. This is the start, and the goal is to add more wrestling-specific content, wrestling-specific events to directly compete. I've directly heard their partners speak to that publicly about, hey, you can just join Rokfin and we can have a bunch of mini Flow Wrestlings on Rokfin and there'll be no need.
Your Honor, can I object on hearsay to this?
Yes, you may. Would you like to?
Yes, please.
Sustained. You have the ability to. It's up to you as to whether you choose to or not.
Is my volume better now?
Sorry?
My volume better now?
Oh, much. Thank you so much for turning that up. That's way better. Thank you so much. So it's 10:30. I need to give the court reporter a break. So we'll come back and pick up with Mr. Windler with questions by Ms. Burgess after a 15-minute recess to give the court reporter an opportunity to rest up. We'll be in recess for 15 minutes.